So welcome. I'm Catherine Wilhelm, Executive Director of the U.S. Asia Law Institute at NYU School of Law. And this is our Asia Law Weekly Speaker Series. So this week's speaker is Professor He Xin of the University of Hong Kong Law Faculty. He is a prolific writer about Chinese law and society. And the topic is his latest book, Divorce in China, which obviously is about divorce, but it's also very much about the courts and judges and how the incentives of judges as they go about their work affects the decisions that they make. And I want to say that it's really a terrific read. It's the rare law book that is full of vignettes of humanity. Because of the many case studies he includes about divorcing couples and their conversations with judges. So the focus on courts is not new for Professor He. He's written extensively about China's courts. In 2017, he published, co-authored together with Kwai Hang Ying, a book called Embedded Courts, Judicial Decision-Making in China, and it won the Distinguished Book Award from the Asian Law and Society Association. And a few weeks ago, we published an essay that he wrote called Judicial Reforms Under Xi Jinping, which you can find at our website. We can put a link in the chat panel. And his essay sums up very concisely what has been achieved by the very far-reaching reforms that have taken place in China's courts over the last decade. So I highly recommend it. And we may perhaps, depending on time today, get into some of that territory as well as the subject of the latest book, Divorce in China. So without any more introductions, I'm going to give the mic to Professor He to make some opening remarks. And then for the second half of the program, we will be taking questions from all of you, and we welcome you to please put your questions in the Q&A panel as we go along. So over to you, Professor He.
Thanks, Catherine, for your very nice invitation and also very generous introduction. So it's always nice to be able to speak at NYU, even though it's virtual this time. So as Catherine just mentioned, I'm mainly going to talk about the book today, and then of course I can't cover every aspect, so maybe just some aspect of that. And I'm going to talk like about 15 minutes or to 20 minutes, then we'll have the discussion. All right, here is just the introduction of the book. I'm showing this simply because there's a discount code out here. So if you really want to buy the book, so there's a 30% of discount, and you can chase this code when you really need it. And then I will introduce a little bit about the divorce and divorce litigation in China in the first place. So nowadays it seems that the divorce has been really increased in China. So it's unlike the situation in the 80s or 90s or even in the early part of the 2000s, right? So nowadays, some statistics would say that 30 or 40% of the marriage actually indeed end up in divorce. And the number actually is higher in big cities such as Beijing or Shanghai, right? So, and then not all of those divorces have to go through the court. Only a tiny proportion of them. The number actually varies across years, but it's about more or less like 1.5 million divorce litigations each year in Chinese court, and others just can be go through the civil departments, civil department basically, and then you would not need to go through the litigation process. And then of those divorce litigation, 70% of them actually are filed by female, right? So there are many reasons for that, but that's basically sort of pattern. So I would say the majority of the plaintiffs are female. So about a little bit about the data of my book. So this is basically qualitative research. I attend court hearings and talk to the judges, sometimes with the lawyers, sometimes with the litigants as well. So I basically collect data from the two basic level courts. One is in Guangdong province. It's very close to where I teach. So I've been to that court for maybe the last decade. Visit that court almost each year until recently. I also went to another court in the Shaanxi province, and that's more intense. So I stayed there for 1 month or two, and then basically tried to collect whatever I could during that period of time. And then these two basically form a contrast, see how the judges in different areas handle the issue, and then the composition of the litigants also quite different, right? So anyway, that's the data collection. And then let me introduce a little bit about the criterion for divorce in Chinese law, right? So the principle is very, very simple. So the arching principle for divorce or not is someone shall, so everybody knows Chinese law, may be familiar with. It's called a breakdown of the mutual affection, right? So to what extent the mutual affection between the couples has breakdown. But this is very, very abstract principle. It's very difficult to interpret, right? So we don't know exactly the meaning of the breakdown of the mutual affection. So there are also some more concrete standard, such as whether there is domestic violence, whether the couples has been separated for 2 years, or something like that. But even with that, it's still quite difficult to determine. For example, to what extent we think there is domestic violence, how to define that, right? So how violent will be adequate for a legal threshold, right? So that's the law. It's also vague. It's also a lot of room for the judges to make their decisions, and that's why it makes it so interesting and to see how the judges interpret those principles and make their decisions. So what I'm going to say, basically, those laws are not that violent. Those are the laws on the books, right? So we really want to see what's the law in action, how the judges make decisions in reality. So what I found basically is a routinized approach, right? So it's quite different from the legal principle, right? Whether the mutual affection have been broke down, right? So the first pattern I found is that is this the first time application, right? So if you just come to the divorce court for the first time and asking for divorce, then it's very likely you are going to be rejected, right? So if you keep coming back the second time, third time, you have better chance to get a divorce. And then the second pattern is that is the hearing is going to be handled by a simplified procedure. We all know that in Chinese law, there's two types of civil procedures, right? So one is simplified, the other is regular. The difference is simply that the regular procedure will have 3 judges in the panel. Simplified, basically just on one judge, right? So if the case is being used by a simplified procedure, it's very likely it's going to be a rejection for divorce, right? So if there is handled by a regular process, then the chance actually going up significantly. Why is that, right? So why the legal principles seems to be less relevant, and those procedure characteristics seems to be important, right? So I'm going to give you the answer in a minute, right? So the point, okay. So let me just say a little bit about those so-called highly contested divorces, right? So if one party really insists that he doesn't want to be divorced, then what you see, and then he may have a threat, basically a suicide threat, or just try to killing somebody else, or actually going up to the up-level government for a petition and appeal or something like that, then it's very difficult. It's very difficult for the other party to get divorce. So in that situation, even just very recently, there's a news report about those events, right? So if a man actually is imposing a death threat, then basically the judge are not going to grant a divorce. So usually they just delay the divorce petition, right? So just keep it there, right? So that's time to resolve the problem, right? So that's basically is the pattern. All right. So the reason behind this is basically there are two concerns from the judges. What I find, one is the efficiency concern, right? So they want to resolve the cases quickly, right? So they want to close the case as soon as possible, because that's part of their the workload, right? So they are assessed by those criterions. So the more case they can handle, they can dispose, the better the performance they get, basically, right? So they need to resolve those cases as soon as possible. But they also have another concern, that's stability concern, right? So they want to make sure when they actually make the decisions, there's no such appeal, no petition, no suicide, no other malicious instance threatening the social stability, right? So then if you combine those two, basically you will find that the previous routinized approach is the best solution, right? So if you are first timer, so you come to the court and for divorce, it will be much easier for the court just say no, right? So because a no means the case is closed immediately, because the judge doesn't have to go through the process of dividing child custody, property, right? So there's no such thing of enforcement as well. It's basically no, you go back, right? So the case is closed, right? But and then you also satisfy the stability concern, because if one party just come to the court for the first time, he doesn't get the divorce immediately, but he or she still have hope to get a divorce. So as long as those people still get hope in the later petitions, they will not cause many problems, right? So it also address the stability concern, right? So that's also why if one party really insists not being divorced, then and actually impose realistic threat to social stability, the judge is not going to take any risk to grant the divorce. They just delay the decision, basically, or to try to mediate the case, right? So try to persuade both parties to accept a certain settlement. So that's basically the approach and the reason behind why you have this routinized pattern, and then basically those who have very important consequences for women, as I'm going to explain that immediately. But before that, I'm going to show some slides, right? So this is a picture I took when I was sitting in on one of the trials. You will see that everything is recording and then actually streaming. Some of those streaming live across the nation, so you can get access for that, right? So and this basically is not what you can see from the court hearings. This is the assessment criterion tracing every judge's workload on their computer, right? So so they have carefully listed those numbers and trace like who done what, and then who is how many cases are left behind, any cases has been appealed, this kind of thing, right? So it's actually the judges are under huge pressures under that work environment. And then you can see this is the gate of a court, right? So, but it's not that you can't get in easily, right? So you have to go through a certain screening process, and then the police car is always there and make sure that no incidents occurred. And this is the door for the petitioners, right? So it's not for the regular litigants. So you have a petition in a court, and you have to go through these actual mental detectors. So that's why, because of those concerns, judges choose the most efficient yet safest way to handle those issues in divorce cases. And the gender consequence is quite obvious, right? So when they make the decision in such a way, basically they allow the forces of inequality in other aspects, such as social inequality, economic equality, or cultural inequality, to get into their decisions, right? So we know that the Chinese society is not that gender equal, right? So there are always social inequality or economic or other aspect, right? But the judges, when they're making their decisions, they allow such unequal forces to get into their decisions. So let me just take one area as example to illustrate this point, and that's domestic violence, right? So what I'm arguing here is that domestic violence is trivialized in this process. In many ways, you will see that China has a lot of instances of domestic violence. It's very popular, right? So, but it's really being addressed in the divorce litigation, right? Let alone compensation. So many cases filed are just basically persuade to withdraw, right? So if you just file a divorce because you suffer from domestic violence, then it's very likely that the judge will just say, hey, maybe you don't really want to go through this. It's only natural that wives are beaten up, right? So it's common, right? So then they try to persuade you to withdraw the case. And in case of settled, basically you see that domestic violence is always erased in the mediation process, right? So this is basically a stunning case that when I'm doing my field work, right? So in that case, the woman filing the petition claimed that she has been beaten for more than 600 times, right? So and the experience that she described actually was horrible, right? So she was beaten out like in front of her father or something like that, right? So and her son was beaten as well, right? So and the judge was very professional, right? So she immediately tried to locate the evidence of the violence, right? So she found she got the defendant to admit that she once choked the throat of the plaintiff, right? So then later on, the judge told me that actually that piece of evidence, that confession was enough. But later on, they decided to mediate the case. They agree that the marriage is over, right? So they will just move on to divide the property, and that's it. So the original detected and found established domestic violence was totally forgotten in settlement process. Nobody talked about that. They just talked about how to divide the property, and that's it. Right? So that's really a common phenomenon. And the reason is simply that in the settlement process, the judge doesn't really want to bring up the issue of domestic violence, because that would basically invite resistance and confrontation from the defendant, and then would actually make the settlement more difficult. All right, so if it is in cases that is adjudicated and domestic violence still barely get recognized and barely compensated, there are a lot of those numbers to show this, right? So Ethan Michelson at University of Indiana run a quantitative analysis, right? So using many of those cases, he shows that if you want to make a claim on domestic violence to get a divorce, but that actually do not increase your chance of getting it, right? So even though domestic violence, as I just showed, is a legal threshold for divorce, that means once domestic violence is established, the court and the judge shall grant a divorce. And then you also have some other research to support this, right? So Professor Chen from another university shows that out of more than 400 litigants, only 3 eventually get a compensation due to domestic violence. And even though, 15% of the litigants will claim the existence of domestic violence. So the percentage here is extremely low. And we also look at protective orders. This is something, some mechanism which is very new, just newly introduced in the anti-domestic violence law. The point is to prevent the offenders from getting closer to the potential victims, right? So, but the numbers so far has been really low. What I show here is actually outdated, right? So the 2000 in 2018, but even today, if you get the new numbers today, and it's still very low. It's across the whole country, maybe there's something about 6,000, less than 6,000. So if you just look at the number here in the year 2018, you will see that these 2,000 orders are actually from more than 3,000 courts, right? So that means for the whole year, one basic level court will not, on average, grant a single protective order, right? So, and then there's out of 1.5 million divorce cases, and then of that, there's 15% or 20% claiming the existence of domestic violence. So those gender issues also exist in other aspects, child custody. In many situations, you will find that the plaintiff of the women have to trade in their child custody to get consent of the defendant to say yes on divorce, right? On property division, we also see that they have to trade in their property. It's extremely difficult for those women in the rural areas, I would say, because when they're married, they came to live with their husbands, right? So when they get divorced, it's almost impossible for them to keep on living in husband's village, right? So then it becomes meaningless for them. So they have to give up those land, or actually for very little consideration. And then sexual harm is another aspect to show that even they claim they suffer from those harm or violence or whatever. So the judges really look into it. They just brush away, right? So at best, they try to use this as a bargaining chip to get a settlement, and that's it, right? So overall, you could see that if the case is mediated, you'll find the weak party in this scenario usually between divorce and the son and the like, right? So the law is very clear. The law is independent, covering each aspect, each issue, right? So whether to grant divorce, whether to grant who has the child custody and how to divide property. They have independent set of rules to trade with each other, right? So, but once the case is mediated out there, the judge usually force the party to trade different aspect, the most important issues in divorce, right? So if you want to get a divorce, then basically you have to give up your son. So eventually we get this. I know it's very well written and then well intended, right? So, but the enforcer of the law, right, the enforcement seems to be pretty poor and very sad, right? So the judge can't really do that. They thought the implementation of the law, and then they allow those social unequal social forces and cultural forces to get in the process and eventually disadvantage women in this process. And that actually is very difficult to deal with, right? Because on the one hand, they want a judge to implement the law, right? On the other hand, they also want to control the behavior of the judges. So that's why the state and the court judicially introduce a set of those incentives mechanisms to make sure that the judges are doing the work, right? So in this process, the law is just one aspect. There are also other considerations such as social stability and efficiencies. And then once those things are combined together, you got into this dilemma, right? So actually, it's not easy to move things forward, right? So we talk about many other options to improve the law, to have more trainings on judges, to increase the gender consciousness, etc. But actually, it doesn't have much. It has some, but it actually did not change the situation significantly. Right? So that's basically the conclusion that I've come to. I think I'm going to stop here.
Okay. Thank you so much. That was a really great summary of a book that is just full of so many different things that we could spend our remaining time talking about. But I want to maybe just start with a very simple question for you, which is what was it like for you to get access to these cases? So you explained that you were going back repeatedly to a couple of courts, I guess, in 2 locations. How did you work out the arrangement with the courts or with individual judges to sit in on their mediation sessions? And what was that like? Were the parties to the divorce case meeting with the judge in the judge's office, the judge's chambers, or were they sitting in the courtroom? You showed us a picture of a courtroom. Were they meeting in a courtroom in a very formal setting like that, or were they sitting in the judge's office? Or what was the atmosphere, and where were you when they were having these sometimes very intimate conversations about their marriage?
Yes, that's a long history. So as you know, I've been doing research related to code for quite a while. So actually, I bumped into this divorce topic quite accidentally, right? So that was about 15 or 14 years ago that I was doing some research on other aspects of the code. Is about, I'm sure it's about debt collection in the Pearl data, right? So and then I was looking at the files, like it's very boring numbers. So I mean, who get what, right? So and then a judge on the neighboring office just came over for a chat, and then he talked to me about this. He was complaining about basically the legal education in China, right? So he complains that the knowledge we receive from the courtroom actually has nothing to do with what we are going to use in the court, right? So, and then he raised this example about the routinized approach, right? So you don't grant a divorce for the first timer, right? So I was really astounded by what he just said. Like, I mean, my training as a law and society scholar basically immediately, like, I mean, so the forced me to explore and ask them their permission to whether I can sit in the courtroom back then. So back then it was very easy. So it's the courtroom is actually full of people. There's a place that you are allowed to sit in as long as the judge allowed you. You know the judge. So the participants, the litigants, basically have their relatives to sit in to support them as well. And there's also judges, and then there's also people from the next sessions because they're waiting there. So I'm invisible for a long time, right? So my co-author Quan used to describe me as the fly on the wall, right? So nobody will ever notice that my existence. So that has happened for quite a while, and then later on there's such lure to basically it's out of the concern of privacy. So the divorce case is not supposed to be public, like, I mean, be open to the access to the general public, unless the related agree. Right? So that makes things quite difficult, and then not only directed areas such as in the court in the Peru Delta, right? So sometimes the judges find it very difficult for me to sit there, and then but they managed to allow me to just look at the recordings of the hearing.
Mm. So, Professor Ho, we're experiencing some.
I don't raise any questions. I just watch.
Mm. Yeah, Professor Ho, when you're speaking, you're breaking up, and there's a little bit of choppiness in your audio. We're missing a little bit of the sound. I don't know if you have any other devices online right now. Maybe if so, turn them off so that the load on the Wi-Fi is a little less.
Okay, let me see.
Well, you can't turn off your computer, of course, but maybe take your phone off, or I don't know if anybody else is using it. We're missing little bits of when you speak.
Is this better now?
Well, this is good now, so we'll hope that it stays.
I don't think so. So it's,
okay.
Maybe just that's the situation. There's not much we can do about it.
Not much we can do, maybe. Yeah.
So that's where. So that's in the developed area, and then in the hinterland area, so people are less concerned about those the presence of the strangers or whatever. So basically, I'm regarded as the friend of the judge or colleagues of the judge. So they sometimes there are also other judges in the room. So when they try to mediate the cases. So I don't see people protesting or the lawyers protesting. Someone like, I mean, they once, like, I mean, the body language of my informant judge shows that I'm her friend or his friend. So then basically people just my presence. So that's why that some of those sessions were followed by me, right? So I would say that. So it's just like that.
Mm. So one of the most stunning and probably disturbing aspects of your research is the light that it shines on domestic violence and on the reasons why domestic violence still remains such a serious problem in modern China. And we don't have good data, so it's a little hard to be able to examine trends in terms of, is it becoming more or less serious over the decades, because the data is so poor. But anecdotally, it seems to be quite dominant or quite pervasive now in cities as well as in rural areas. It's not simply a problem of economic backwardness. It exists, as we know, in all countries, in the highest income levels and the highest education levels. It is not something that you can assume a society develops out of. And I'm very interested in this because the anti-domestic violence law that took effect in 2016 was the product of something like 25 years of intensive efforts by legal reformers, by women's advocates to do something about the domestic violence problem. And it's certainly known that that the law was not being well implemented. But what we see from your research is almost that it cannot be well implemented as long as the courts incentives, as long as the judges' incentive structures remain in place as they are. In other words, it's not a question of improving the wording of the legislation. It's simply that judges are not incentivized to enact the law as it was written or as the advocates hoped it would be enacted. And in fact, it's not their priority to do that. And it seems then as if we're kind of up against a brick wall in terms of ending this really serious problem for women. So what would you recommend that women's advocates, and here I'm talking about organizations, civil society organizations, and public interest lawyers, lawyers like Guo Jianmei and her colleagues, what would you recommend that they should do in order to activate the anti-domestic violence law, in order to actually have the law's promise be fulfilled? As you said, training judges, this is something they've been doing now for years. They've been training police as well. They've trained doctors and nurses. What should they do?
I think the law definitely have improved the situation quite a lot. So I don't want to dismiss the impact, the positive impact of the law. I may have to discount its impact. So if the analysis of the book is right, and basically you go to the incentive structures, or put it differently, you want to offer better protection or support for the judges as well. So it's if you look at the situation of the judges when they make their decisions, they're really under tremendous amount of pressure. So when they face those violent litigants, right? So when there's such a malicious instance occurred, they are the person who that are immediately called upon and then be held responsible, right? So the first thing if there's any mishandling of the case, any gift or whatever. So if there's any corruption out there when you're handling these cases, right? So any inappropriate behavior. If it's not, and if that is clear, then they move to the whole process of the cases. Any procedural issues that you didn't follow. So, and then if the instance got more attention, such as the media and broader audience, like and more protests, this kind of thing, and then the judges may subject to those discipline actions by the party disciplinary department. That's actually beyond the court authority, right? So the situation will be even harder. So the judges are not offer the support of the authority. They are treated as the judge themselves the judge call themselves as the migrant judges, migrant workers, right? Mm-hmm. So I mean they're not offering the basic dignity to protect themselves. So they become so cautious when they're making those decisions. So one way to improve the situation, if you compare the situation in China and in the United States, then you'll find that those so-called instances occurred in the United States as well, right? So, but not that often, right? So the difference is simply that in the United States, people may have more respect for the judiciary, and then maybe they enjoy a high level of legitimacy, and then the judges at least are not held accountable for such a sad instance when somebody get killed or anything suicidal occurred, right? So, but that's a situation in China, right? So the judge have to respond. They feel that they don't really enjoy the prestige over the litigants. There's not much they can do about those hooligans, right? So they just try to use all kind of the stress. They could just tell the judges, I know where you live, right? So I know where your kid go to school, right? So I know where's the campus and this kind of thing, right? So they just try to find a way to handle the case as efficient.
Just to be clear, not everybody who's listening may understand the social backdrop you're talking about. You're saying that one of the parties to the divorce, to the claim of domestic violence and therefore the divorce, is fighting it and doesn't want the judge to publicly in the records decide that yes, a person, usually the man, usually the husband, has committed domestic violence, and therefore the divorce is granted. This is what you're talking about, the husband who's fighting a divorce claim by the wife, who says she's been the victim of domestic violence, and the husband and his family kind of ganging up on the judge and saying, if you rule for her, we will come after you. We know where you live. We know where your child goes to school. And this is the hooligan behavior you're talking about.
Yeah, that's right. So usually those threats come from those who resist being divorced. So as I said, I mean, 70% of plaintiffs seeking divorce are female. Mm-hmm. So and then you don't go to the court for divorce unless there's one party is resistant to the divorce, or there are unsettled issues in the divorce, such as child custody or property division. So if both parties can agree upon all the issues on the divorce, they can just go to the registration department and get the divorce certificate as soon as 5 minutes. So that shouldn't be a problem. But just once it is in the court, usually is what we call a contested divorce. One party doesn't want to be divorced. That's the major part. And then of course there are all the other issues like
Mhm.
how to handle
Yeah.
the aspects as well. But
Yeah.
the majority of them is the one party resisting. So then, so they could have those threat to the judges, because it seems the judges, it seems that it's the judge who is destroying their family. So so they want to just retaliate and then just also do something
Right.
to the judge. And yeah.
And if the judge said, I find that there has been domestic violence here, and therefore I grant the divorce, what are the other consequences that might follow? I believe you mentioned compensation is an option, so the victim of the domestic violence could get some kind of compensation. How often is that? Well, obviously, very, very infrequently that's triggered, but what level of compensation would we be talking about? And is there ever any possibility of criminal punishment? My understanding is that that is also incredibly rare, that anybody would face criminal charges for domestic violence.
The compensation, if it ever occurred, is in the form of monetary compensation. So when they divided properties, maybe the women are slightly favored. I think that's the usual form. A divorce case actually is a civil lawsuit, so it is not criminal.
Right.
The judges have no incentives whatsoever to transfer such a civil lawsuit to a criminal one. They are there to, again, they're there to resolve the cases, to dispose cases. They're not there to create new disputes or cases. So that's the last thing they want, basically. So even if there is domestic violence, even if the DV is established, they would just simply find a way out and then try to address that within the case. I personally didn't know, right? So they may inform the other party, the other branch of the government to be involved, say to ask the police to give some warnings. So according to the anti-domestic law, and then it's very rare, extremely rare, I would say. So actually to round up the defendant, the offenders, to make sure that they don't just try to give them some warnings and keep them in custody for some time. I think that's the kind of thing that might happen, but again, it's against the incentive structure.
Now, you found that when judges did issue protective orders against the abusing party, that those orders were generally effective, right?
Yeah, I think so. So from my experience, from my feedback from the judges in those areas, I think a lot of men have little idea about what it is. So it's just from the government, right? So they feel threatened. They feel that they have to change their behavioral pattern, at least for the given period of time. So I find it quite effective. I need to do more research. But so far, it seems to me that there are some rebellious, but it's very, very rare.
So the problem is just that they're not being used. And we've seen such horrific videos in the last few years as people. It's a bit similar in some ways to the videos that come out in the United States showing, violence, police violence. We see these videos on Chinese social media of domestic violence actually occurring, of women being beaten. There was one of a woman being pushed out of a second-story window. There was another woman who was set on fire. And these have really shocked the country. Presumably over time, this kind of visual evidence of horrible abuse would have a social impact. So I'm wondering, is the obviously the long-term solution has to be that there's a change of attitudes across society rather than simply on the part of judges. Is this where people should be putting their efforts, would you say? Is this the direction for future lawyers and activists to be taking? Educating society?
I think if, so in those horrible things, when in the cases that those things happened, I think many of them actually is a delayed decision for divorce. So if they are divorced earlier, then may not occur. Like, I mean, so it's preventable in many of them. Like, I mean, I'm sure you're talking about some recent stories reported by New York Times and something like that. So if the court make a immediate decision, judging from the facts and based on the normal interpretation of the law, the domestic violence shall have been established, and then the divorce shall have been granted, right? So then those things might be prevented. So that's at least. I still believe that, I mean, if you allow the judge to just have the reasonable interpretation of the law based on the facts, and then as far as the domestic violence issue is concerned, so then a lot of those horrible things could have been prevented. And of course, in the long run, you still want society to have a better gender consciousness on these issues, like, I mean, whether it's something is appropriate, whether it's doable or not, whether women can be beaten because they are up or something like that. So you change the overall culture, but to the core, I still believe, like, I mean, the judge plays an extremely important part in this whole process, this project. Right. So you work on other aspect, but if the judge can, I said, I don't have to repeat myself. So if they just do what they are supposed to do, following the law, the situation could have been much better.
Right. Well, this takes us to the other, what I saw as the other main takeaway from your book, which was the emphasis on incentive structures. And it highlights an aspect of Chinese legal implementation that I think isn't often paid attention to: the annual evaluation of all government employees. The in the States we talk about KPIs, key performance indicators, but in most institutions, I think in the U.S., these are not such life and death matters, or perhaps we simply don't talk about them as much. But in China, these are really critical, that the year-end evaluation process, where if you're a judge or if you're a policeman or any government office, you are evaluated on a set of indicators. And if you do not perform well, you are punished in some way administratively. You may not be promoted, and so on. Are the sets of indicators for the judges are what basically are forcing them to emphasize efficiency and stability, right? Because if there is an incident, if there's a so-called mass incident that occurs as a result of a judgment that a judge issues, then that is going to show up in their indicators. And if they don't handle the cases within time, that will show up in their indicators. So could you talk a bit about how these indicators work and whether there has been any discussion in the course of the judicial reforms about making them more flexible so that they actually allow judges to implement the law instead of worrying about their own performance?
That has been a persistent issue within the judiciary. Since I have started working on the project of the judicial reform and court, so has been there. So especially the efficiency issue. So originally the talk about Xiaoyang was the president of the Supreme People's Court. the emphasis was efficiency and justice. Right? So Chinese court always under this pressure to meet the timelines. So the civil procedure will make it very clear that 6 months for the regular procedure and then 3 months for the simplified procedure. So they have to be get closed within that period of time unless there are specific special permission and of course also get approved. So if you compare the China's handling and with the U.S. situation or any common law jurisdiction, you will see that the Chinese judiciary is extremely efficient. Right? So in Hong Kong, you may get 1 year or 2. In the United States, maybe 3 years. I don't know. So delayed justice is no justice. We all know that. So that's basically it's a concern of the Chinese authorities for legitimacy. Right. So they want to improve the efficiencies, and then that has always been like that, and especially. Even after the recent reform, and it seems that the number of the judges has been reduced, and then the case number keep going up. So they are under even more pressures to handle the cases within the deadlines. So if you can't really finish the cases in time, so then the different court within the given jurisdictions will also be ranked together and then to be competing with each other to show that whether the individual court has actually meet the expectations, etc. So there are many ways to play with that too, but basically that has been a long story. And then for the stability concern, is introduced, I believe, since the Zhou Yongkang period, right? So back then, it seems that the social stability and social harmony has been emphasized.
Okay, in the early 80s. In the
right.
early.
So then, in the mid 2000s or something like that, or early 2000s. So then that was introduced as another indicator, and then it becomes so common that. That's basically is the judge's thing that a judge will want. Like, I mean, it seems that it's the judge mishandle the cases and they can't really do their work, right? So they are incapable of handling their litigants. So they make the judge, the court look bad, right? So you attract a lot of negative media report as well. So there are many ways to try to prevent that, and it has been clearly written in the assessment criterions. It's all clearly understood among the judges. So nowadays, of course, there are a lot of those discussions about how the assessment criterion shall be adjusted. Right, so originally from a different period of time and depending on the political being, the mediation is emphasized, and actually was not no longer emphasized again. Right, and so but for the two criteria I just mentioned, efficiency and stability, has always been there. Right, so I don't see. You'll be relaxed and then it'll be revoked. You'll be job off or canceled, abandoned sometime in the near future.
Right. Well, if the government really wanted to prioritize protecting women, for example, it could put in an indicator in the evaluation process for women's cases that are handled in such a way that they actually implement the provisions of the law on the protection of the rights and interests of women. You could make it an indicator. So in other words, what you prioritize, you measure, as they say. And if you don't measure it, that means you don't prioritize it. that leads me to one question. Our faculty director, Jose Alvarez, is asking about China's obligations under CEDAW. And that these outcomes that you're describing clearly are inconsistent with China's obligations under CEDAW. And he asked whether the gap in performance has been has this been talked about? Has anybody drawn attention to this in order to highlight the ways in which China is failing in its international obligations? So if you wanted to prioritize, if China wanted to show that it is being very compliant with its CEDAW obligations, and certainly President Xi has talked at the United Nations about women's interests. He did that a few years ago at the anniversary of the 1995 Beijing Women's Conference. If they wanted to show that this is a matter of national pride, that women hold up half the sky and we do protect women, they could put an indicator into the evaluations for judges in civil courts who handle divorce cases to say, were the women in these cases actually given compensation when there was domestic violence? Were they given equal were they given their land rights if they're rural women after divorce, and so on and so forth? In other words, it could be measured and therefore that it could be enforced. So do you think what I'm suggesting is even feasible, first? And then secondly, as to Professor Alvarez's question, is anybody making any kind of, doing any advocacy around the CEDAW obligation?
For the CEDAW question, I don't know of any attention has been made to the link between these two. So the incentives mechanisms and gendered outcome. So anyway, this is our sort of the new book, right? So the book is yet published in China. So it's people will think of may not think of these two as such a crucial part of the consequence, right? So of course, I hope that people would have more attention and on this issue, and then push for the improvement of the situation, right? So as to the suggestion that you just made, I'm not sure. So because the assessment criterion is applied to all judges, not just the judges in the divorce department, right? So those requirements are universally applied to basically every adjudicating staff, right? So if you want to make a special note for a divorce judge, how about the judges of land takings, right? So or any other aspect of personal injuries, and then I mean, there's many of those issues related to social stability. It's very difficult. May not to change the incentive structure directly on the divorce judges. There might be other ways to improve the situation a little bit, I would say, right? So for example, mediation. Mediation actually seems to be supported by many people, actually, but as I have already shown, it has very negative outcome for women, right? So you allow judges to meddle a lot of things which should not be put together, right? So you allow them to erase domestic violence in the settlement process. You allow them to trade in the child custody with a yes on divorce, right? So and everything is on the table. Like I mean, so it's just I think that's needs some change as well. Uh, for the incentive structure, if you want to be realistic, I think there's still some room for change, right? So then basically you really allow them to have a more room, like I mean, make the decision. You don't treat them as criminals when there is any instance. So you treat them, yeah. You don't treat the judges as criminals and suspects, right? So you treat them with dignity and offer them support in the first place. They are not, as long as they are not misapplying the law or take corruptions or briberies and this kind of thing, and then they should be supported instead of scolded and demoted and punished and penalized and this kind of thing. So then it's totally different mindset, right? So I don't think you can just take out certain aspect in the divorce cases and then grant them special approval.
Right. Well, if judges were allowed to decide just based on the law, then as you've described it, they would be telling some of the men who don't want to be divorced or some of the domestic violence abusers that this behavior is wrong and that now first of all, the woman is completely entitled to divorce because your behavior was wrong. And secondly, you must compensate her. That would be a powerful lesson to society. I mean, that right there would have a very important messaging effect. So judges could be a means of getting the message across society about domestic violence not being tolerated by the Chinese government, if they were allowed to do so. But as you say, then the rest of the government structures need to back the judges up and ensure that those men and their families do not come after the judges or do not go after the women. They would need to actually enforce the law and prevent them from engaging in what you describe as hooligan behavior. But if that were to happen, if all of the agencies of government were to enforce the law, then we would very quickly, I think, have powerful message go across society that domestic violence is not permitted, and that judges actually speak with authority.
Right. So the one lesson, I mean, or one observation about the operation of the Chinese government and or the authority is simply that if that get the attention of the top officials, if they want to do that, then they are able to find ways, right? So they can change something immediately, and if, such as the corruption or the political ideology thing, they can do these things effectively, like financially or whatever. So the point is that to what extent they really think this is on the top of their priority list, right? So if they really believe this is the court improve the governance, improving the governance of the society, and then if you allow the more room for the judges, actually the society are better off instead of just using the judges and the court as the very primitive type of tools to repress the society, right? So then for the very difficult task, to deal with the marriage issues. So if you allow more freedom and more flexibilities for the judges to interpret the law and then implement the law, I think that's important message. And I personally try to get that across. So anyway.
Yeah, the message that comes across in your book is that judges are not really doing what we would sometimes think of as judging. that they're basically administering policy. And to some extent, judicial decision-making is very similar to administrative decision-making. Would you agree with that way of putting it?
Oh yes, of course, and that's not unique to Chinese judges. So according to Yale professor Damasco, I think that's or Martin Shapiro, I think that's universal. So it's just the difference is only at the degree and extent. So it seems that the Chinese under the Chinese regime, the function of dispute resolution and social control are equally important. So sometimes maybe social control is more important than dispute resolution, right? So to implement the law is one thing, and then there are always other aspects of social governance, the social policy issues out there. But it seems that if you compare those different jurisdictions, you will see that the emphasis on social policy, implementing policy, are actually more visible, maybe salient in China's regime.
So a couple of the questions that we've gotten ask about the training of judges. What kind of training do they have? Have they been trained to do mediation? And I think a related question is about whether there's any difference that you or others have found between the way male and female judges handle these cases. And I say that's related because I think that might go to training as well.
Training, they have gone through some trainings. Some areas of the judges have gone through the trainings. Basically, it's about how to view the evidence of domestic violence, how to be alert on the gender issues. So indeed, I found that very effective too. So when I was doing the field work in the Guangdong province, I found the judges there very careful about the gender issues. So if I raise that, they're guarded. So they're very clear that about my intention. So they know what I'm looking at, and then they try to address that. So they try to, to cover that. To show their neutral position in making the decisions. In many ways, they are right. So from very basic. From a first glance, you will see the difference. You notice there's a gender issue when they're making those decisions. So you have to get into the whole process and then do the analysis, and then you will find, oh, there's such an issue, such as the one that I find on the erasure of the domestic violence in the settlement process, because the judge has already located evidence, and then she can decide either to mediate or to adjudicate. Right? But the law also allowed her to conduct the mediation. Right? So she just asked whether the four parties can just mediate, and then of course they agree. Then you have to go ahead and do the mediation, and then later on I find, okay, how about the issue of domestic violence is just forgotten, right? So anyway, the training will be useful for them, and then the judge there is also extremely professional, smart, and then immediately locate evidence of domestic violence. But in the hinterland area, where the judge received no such training. Initially, she has no idea, about the question I'm going to explore. She would just say, actually, we are very neutral, we are very equal. So the law protecting both genders, we are not biased at all. There's not such thing at all. So I don't think there's anything there for you to do the research. But later on, once as I have more and more those cases exposed and then talk to her and then him, and then they realize, oh, indeed, there are many of those issues. If they could do it again and to make the decision again, and then they may change their positions. They may do better, and then to try to favor. I believe those trainings about the evidence issues, about the general gender issue as well, and then how to locate evidence, and then how to offer some psychological help, how to use mediation more cautiously, and then some judges and some officials, actually the court officials, talk to me that maybe we can just simply inform the parties. If you want to have a mediation in this process, then you just basically forget about the issue of domestic violence, right? So you seek their permission in the first place to inform them the possibility of losing compensation if you choose to mediate over adjudication. So they need to be trained. They need to be informed. Those trainings shall be useful. I don't want to dismiss them, but simply my emphasis is on the incentive structure. So what's the other part of it?
Was about a difference. Is there a difference between how male and female judges handle the cases?
Well, you can basically predict from my argument. So I don't do the quantitative analysis. There are some related research. One of the authors was my student. So they managed to show whether there is such a contrast, but the conclusion is quite straightforward. No difference between them. Basically, no difference. There's some slight difference, but statistically insignificant, of course.
Because they face the same incentives.
Exactly, because the incentive structures are exactly the same. So how cool there's many significant gender differences among the judges, right? So to be really honest, if I were a judge, so I won't be able to do much better than those people, because I would subject to the same kind of incentive structure as well. I'm still afraid that any retaliations, any negative impact on my performance, right? So I would just try to dispose the cases as soon as possible, right? So as soon as those parties accept the decision, right? So if I can repress certain cases, I will do that as well, right? So because that improve my performance and then reduce my workload, right? So that's basically is the. You could also, when people also ask the regional variation, right? So which is quite similar, right? So in the coastal areas, in the hinterland areas, there must be differences. China is such a vast country. I mean, the regional variation is obvious, but the incentive structure is more or less the same. It's essentially made and implemented. So the emphasis may be different. The caseload may be different. So you will see the difference, but those differences are relatively minor if you look at the main pattern.
Right. So we still have quite a few questions. Let's sort of try to quickly go through a few more before we finish. We have a former judge in the audience who is asking about whether there are any provisions in Chinese law for one party to pay money to support the other party. And there is another question asking about prenuptial agreements. So maybe could you talk a little bit about, this question of, one party supporting another, what are the property arrangements that are made?
There's no arrangement for alimony. So basically, so when they determine the property issues, they just divide the mutual property, right? So the law basically says that the women's and children's interests shall be protected and favored But as well illustrated, that's not the case in reality. So the other thing is that China, of course, has the law regarding the child support. So if one party get a custody and then the other party shall provide a certain amount of child support, and that has been stipulated, and then I don't see much issues out there. So if the party agreed upon and accept,
is it typically given? Is child support a typical feature of most cases where there is a child?
Yes, I think so. So because the law basically have very clear stipulation on that. I mean, something like, I mean, I forgot the range of the percentage of the income, right? So unless the party just say, one party just say, I don't want it, right? Otherwise the judge will just make the decision accordingly. So I don't think that's a big issue out there. Right. And what's the other one?
Well, there's a question here about, this is interesting, about the Supreme People's Court's guidelines on domestic violence being applied at an experimental level for divorce cases. Now, these guidelines predated the domestic violence law. These were the 2008 Supreme People's Court guidelines. The question is whether they had any impact when they were experimentally applied, and how those guidelines compared with the impact of the domestic violence law now that it is being applied, because the guidelines were more detailed. So the question is whether having more detailed guidance for the judges makes a difference.
It's a very good question. It's very specific, and the thing is that the 2008 guidelines are not laws, so they're not judicial interpretations. It's just guideline issued by applied legal research department of under the Supreme People's Court.
Right.
So so the judge have no obligation to follow them, but they could use it to support the decision. So in some areas, I do see that they actually use that. So there is an impact on the. So
in those cases, but in those cases where they used that, was the outcome more equitable? The ones that
I think so. I think so. So I believe so. But again, as I said, that's not other general pattern. So and then incentive structure are still there. So in my book, I describe certain cases, like, I mean, at a child level, the judge actually recognized the domestic violence and then grant the divorce. But that decision was immediately appealed because the man was very angry about the decision. And then obviously the man also make a big trouble, make a big fuss on the appeal level, right? So then the appeal court was the trial court and send the case back to the child level. So the point I try to illustrate is simply that as long as the incentive structure are still there, and then you won't change the general pattern, even if some judges are more general conscious, and then they do apply the law, right? So the law, I look at the detailed guidelines of the 2008, and then it's very specific, it's very advanced, I would say, right? So if those guidelines were implemented, the situation would be improved. I'm pretty sure about that. So, but the thing is that those detailed arrangements most of them were not incorporated into the anti-domestic violence law, right? So the law remains quite vague and general on many of those issues, right? So if I could add a little bit thing is that I also do is beyond this the scope of this book. Then it's about the court treatment of those women who kill their husband because of domestic violence.
Yes.
So the general impression we get from media is that after the law has been changed, in a certain period of time, I can't trace that. It's maybe 2010 or something like that. So the sentencing for those women has decreased significantly. That's the impression we get from the media, because people realize actually those are not real murderers. They kill people because of a reason, right? So that's the general impression. But the statistical analysis shows no change before and after the law has been changed, and then between the different regions as well. So the point once again is that the structural thing are more important. So if the prosecutor mentioned that, and then the sentencing will be lightened, right? So if the court recognizes there's a domestic violence, then the sentence will be lightened. But if those originally structural player didn't do anything, you just change the law, it won't change much.
It won't change much. We only have 2 minutes left, but I think that what you just said leads to a very good final question, which is about the role of lawyers. So if you had mentioned in your research that very few of the parties in divorce cases are represented by counsel, very few of the women. Most of these cases are brought by women, and they rarely have lawyers representing them. Would the situation be improved if they did have more lawyers in the picture? Could lawyers play some of these roles? And one reason there's hope for this to happen, for there to be more lawyers, is because the draft legal aid law that is being considered now by the National People's Congress does provide for some expansion of support for the legal aid system, at least in theory.
Personally, I'm not that optimistic about the role of the lawyers playing in this process. I hate to say that, but most lawyers parasite to the judicial system. So they're going for profit, especially for the divorce cases. Not many professional lawyers are involved. So most of them are so-called legal workers. So they don't get a formal because most of the professional lawyers will get a full license, so just go after other more profitable type of cases. They don't want to get those divorce cases, which is regarded as the other end of the spectrum. So and then another thing is that the judge usually try to restrict the involvement of lawyers in those process, because if the lawyers are actually participating, they may not actually facilitate the goal of the judges. The judge simply want to get a case disposed, settled, and then acceptable for both parties. And then if the lawyers are raising all of these kind of questions, then you may not really have that, right? So it becomes the obstacle for the judges to make decisions. So the tendency of the judges is to try to constrain the impact of the lawyers in this process. So I'm not that sanguine about the role of the lawyers in this process.
Well, we could go on for quite a while because this is fascinating, but we'll have to end here. There has been a request for you to re-show or to repeat the discount code for purchasing your book. Would you be so good as to look at your slide and maybe read out for us what that code is? If we have some.
Okay. Okay. This is the discount code is CSFF 2020. And
no, that's great. Thank you so much, Professor He. This has been fascinating, and good luck as you continue your research in the courts. We'll bring you back next year to talk more about judicial reform. Thank you all for coming, and goodbye.
Thank you. It's really a pleasure.